Last Saturday, Melania Trump didn't just provide a routine statement. She testified under oath before the Supreme Court, an event that has triggered an unprecedented wave of asset seizures. According to judicial documents released this past Thursday, we are looking at a staggering $1.2 billion in frozen assets, including 17 properties and 347 bank accounts spread across 6 different jurisdictions. By Friday morning, U.S. Marshals were already on the ground executing seizure warrants. I have spent hours analyzing these filings, which include a 14-page transcript and over 380 pages of exhibits. What I found is that the former First Lady didn't just answer questions, she provided internal communications and financial records spanning 8 years. The speed of the court's response was remarkable. The 9 justices issued an emergency order just 4 hours after she left the room. To give you some context, Melania Trump has historically maintained the lowest profile of any modern First Lady, but she was subpoenaed regarding presidential immunity and the forfeiture of assets linked to multiple federal indictments. The timeline moved rapidly. 2 weeks ago, the Supreme Court agreed to hear emergency arguments on whether seized assets could be held during appeals. 10 days ago, the special counsel moved to compel her testimony, arguing she had signing authority on 14 offshore accounts. Despite legal objections, the court granted that motion 5 days ago. On Wednesday, Melania entered the Supreme Court through a private entrance at 7:14 a.m. and didn't emerge until 6:47 p.m. What shocked everyone was her approach. She did not invoke spousal privilege, nor did she plead the Fifth Amendment. She answered everything. Reporters noted that the lead defense attorney looked physically ill by the lunch break. By Friday, the Marshals were mobilized. Page 47 of the Thursday filing explicitly states that the witness provided documentary evidence of 17 wire transfers, totaling $847 million, sent to entities in Cyprus, Switzerland, and the Cayman Islands between March 2025 and January 2026. This isn't just an opinion, it's in the court record. Melania had the record showing exactly where the money went, even after federal freeze orders were supposed to have stopped such transfers. Perhaps the most surprising part of the testimony is found on page 112. She brought actual bank confirmations with timestamps, showing that these transfers occurred after the original asset freeze was ordered in November. If you piece this together, it shows money was being moved while the courts were explicitly reviewing the accounts. The pattern is clear. A freeze was ordered on November 14, 2025, yet $847 million was moved between November 19th and December 3rd. An additional $340 million was moved through a Nevada LLC between December and January. All of this was documented by her. On page 189, under Exhibit K, she was asked if she signed these authorizations without knowing their content. Her response was direct. I was told they were routine business matters. I signed where I was directed. I did not know the funds were subject to a court order. She claims ignorance of the legal implications, but provided the proof of the actions regardless. Her own lawyers tried to block the submission of Exhibit K, but the judge overruled them and she handed it over voluntarily. Her signature on those documents is dated November 22nd, 5 days after the freeze. By early January, Melania testified that she discovered discrepancies between what she was told and what was actually happening. Crucially, she consulted an independent attorney rather than the family's legal team. That lawyer warned her of potential criminal exposure if she didn't cooperate, leading her to choose full transparency. The court record notes that she demonstrated a consistent pattern of providing information against her own apparent personal and family interests, which the court used to weigh her credibility in her favor. The consequences were immediate. U.S. Marshals targeted 17 locations across 4 states and 3 countries. Domestically, they hit Mar-a-Lago at 6:12 a.m. Friday, Trump Tower at 7:34 a.m., and the Bedminster property at 8:15 a.m. By noon, $1.2 billion in assessed value was frozen. This level of cooperation and the subsequent speed of the judicial system is something we haven't seen in modern history. The evidence even included handwritten notes from December 14th, regarding conversations with her husband, where she claims she was told the court order didn't apply to them. This direct documentation is why the court moved with such urgency. Now let's be perfectly honest and fair here. The other side raises some extremely important points that deserve analysis. Trump loyalists are arguing that this is a coerced testimony from a spouse under duress, and frankly, some of that logic holds weight. Their first point of contention is that Melania didn't volunteer, she was subpoenaed. The government forced her into that chair using legal mechanisms that have never been applied to a former First Lady in this manner. Secondly, spousal privilege exists for a specific reason. It protects the sanctity of marriage and prevents the government from weaponizing family relationships. By compelling this testimony, some experts argue the court potentially violated centuries of common law tradition. Senator Mike Lee, a high-ranking member of the Judiciary Committee, put it bluntly by stating that this isn't justice, but the criminalization of marriage, where a wife is turned against her husband using the full weight of the federal government. Regardless of your political stance, that's not a minor point. The special counsel pursued this testimony aggressively, and it's true that lower courts initially rejected the subpoena before the Supreme Court intervened. Furthermore, critics point out that Melania's independent attorney might not have been truly independent, with some calling the appointment process a forced compromise. Even Jonathan Turley, a renowned constitutional law professor, admits that regardless of what she testified, the mechanism used to obtain this testimony will be debated for decades because of the precedent it sets. I'm not here to tell you who is right. On one hand, the prosecution's interpretation is that the evidence shows money moved illegally, and Melania provided the documents to prove it. On the other, the defense argues there is evidence of coercion, that her testimony should be inadmissible, and that the entire process violated both executive and spousal privilege. Both of these things can be true at once, which is what makes this so messy. There is also the question of her motive. Some supporters suggest she was simply protecting herself, cutting a deal to avoid criminal prosecution. In their view, this isn't noble, it's self-preservation. We have seen this pattern before, with spouses providing damaging testimony under pressure, from the wife of John Dean during Watergate to various high-profile organized crime cases. Critics also remind us that Melania had her own legal exposure. Those signatures on the transfer documents could have led to felony charges against her. This testimony could very well be an immunity play. Her lawyers have neither confirmed nor denied if she received an immunity deal, and the record remains silent on that front. A retired federal judge noted that before we canonize this testimony, we should examine what was offered in exchange, as immunity agreements don't always appear in public filings. That is a fair question to ask. Finally, there's the argument regarding timing. Melania testifying now, with elections 18 months away, feels politically convenient to many observers. The courts do not exist in a vacuum. What I can tell you is what the documents show. She provided evidence after the subpoena, but she specifically handed over Exhibit K voluntarily, even when her family's legal team tried to block it. That specific move is what bridged the gap to what happened next. This didn't come out of nowhere. Looking back 18 months, when the first federal indictments landed, asset freeze requests were filed immediately. While the courts fought over jurisdictions, the money began moving through shell companies. 6 months ago, the special counsel flagged suspicious transfers to Cyprus and Switzerland. By December, a former DOJ official claimed they always knew the First Lady had more involvement than publicly acknowledged. Wednesday was simply the breaking point where, faced with the Supreme Court's emergency jurisdiction, Melania had to choose: testify or face immediate contempt. She chose to speak, and once she started, she didn't stop. On Wednesday at 2:34 p.m. Eastern Time, the atmosphere in the chamber shifted from procedural to historic. Justice Ketanji Brown Jackson asked Melania Trump directly about her knowledge regarding the November transfers. Her response, which is now etched into the official transcript, was, "I knew money was moving. I was told it was legal. I signed what I was asked to sign. I now understand that was not accurate." The room reportedly went dead silent. Following that statement, Chief Justice Roberts called for an immediate private session with the attorneys. When they resumed with all 9 justices present, which is highly unusual for a testimony segment, Melania presented Exhibits J through M. These weren't just bank statements. They were the handwritten notes and the timeline she had reconstructed with her independent counsel. While the mainstream media was hyper-focused on the flashy headlines of property seizures, something far more surgical was happening in the background. Late Thursday night, a separate filing under case number 247 was registered. It wasn't a referral for Melania, but a criminal referral for 3 specific attorneys who had advised on those very transfers. The fallout was instantaneous. By Friday morning, before the Marshals even began the raids, 2 of those lawyers were intercepted by customs at Teterboro Airport while attempting to leave the country. Their passports had been flagged overnight. By Saturday morning, the Attorney General's office confirmed they were in federal custody. The third attorney, the lead counsel who had actually sat in the room watching Melania testify, surrendered himself Friday evening. We are now looking at 3 high-level lawyers facing obstruction charges. This tells us that the government is no longer just chasing the cash. They are dismantling the legal architecture that made these transfers possible. When you see prosecutors go after the advisors first, they are building a ladder, and every rung goes higher. This is where we have to look at what the experts are saying, because their analysis explains why this matters for the long haul. A former federal prosecutor from the Southern District of New York noted that Melania's actions are textbook cooperation. By providing documents the government didn't even know existed, she effectively bypassed the coerced narrative. Even legal giants like Alan Dershowitz, who has defended Trump repeatedly, admitted that the voluntary submission of Exhibit K was devastating. Once she bypassed her own lawyer's objections to hand over that evidence, the defense's argument for spousal privilege essentially evaporated. Historians are also pointing out that in 230 years, the Supreme Court has never issued seizure warrants on the same day as live testimony. The sheer speed suggests the justices saw evidence of an imminent flight of assets, and based on those arrests at the airport, it looks like they were right. Why should you care about this beyond the political drama? First, there is the literal cost. If that $1.2 billion is successfully forfeited, it goes to the U.S. Treasury, which offsets the massive costs of these federal investigations. Then there is the market impact. We saw futures dip 2.3% on Friday because of the political instability this creates. But the biggest impact is the precedent. This case has completely redefined spousal testimony and the speed of judicial seizure. It has also sent a massive chilling effect through the legal profession. Any lawyer advising a high-profile political figure now has to consider that their advice could land them in a federal cell if it's deemed as facilitating obstruction. As we look toward the coming days, the clock is ticking. Monday, February 9th is the arraignment for the three attorneys. That is where we will see the specific charges and find out if any of them decide to flip. On Tuesday, the House Oversight Committee is calling an emergency hearing, and the big one, Thursday, February 12th. That is when the Supreme Court meets again to decide if these emergency seizures become permanent. If they stay, the forfeiture process begins in earnest. If they are modified, we could see assets released under strict conditions. This story is moving faster than anything I've ever covered because the documentation is finally catching up to the speculation. The reality is that the special counsel's office has been silent since Friday, and in my experience, that usually means they aren't resting. They are preparing the next phase. As we wrap this up, let's look at exactly where we stand and what the next 72 hours look like, because the chessboard has been completely rearranged. Currently, we have a 214-page transcript that has gone public, 17 properties under federal seizure orders, and $1.2 billion in assets that are effectively untouchable by the Trump Organization. Most importantly, 3 of their key legal architects are currently in federal custody. This is no longer just a civil dispute about money. It has evolved into a full-scale criminal investigation where the walls are closing in on the inner circle. The public break between Melania's legal team and the White House is the most significant fracture we've seen in years, and it suggests that the strategy of total unity has finally collapsed under the weight of federal evidence. Looking at the immediate horizon, tomorrow, Thursday, February 12th, is the most critical day of this entire saga. The Supreme Court will reconvene to decide whether these emergency seizure orders will become permanent. If the justices maintain their current stance, the transition from frozen to forfeited begins, and that money is gone for good. Then on Friday the 13th, the Trump legal team faces a hard deadline to respond to the motion for total forfeiture. They are fighting a war on 2 fronts, trying to keep their assets while also dealing with the fallout of 3 of their own lawyers facing obstruction charges. There's also the looming question of whether other family members, like Don Jr. or Eric, will be the next to receive subpoenas now that Melania has opened the door to those 14 offshore accounts. The reality is that the special counsel hasn't said a word since the raids began, which should tell you everything you need to know. They aren't speculating, they are executing. While the media is going to spend the weekend arguing about loyalty and betrayal, the documents tell a much colder story of financial transactions and legal exposure. Melania Trump's testimony may have been a move for self-preservation, but the documentation she provided has given the government a roadmap they never had before. Whether you see this as a pursuit of justice or a political hit job, the sheer volume of evidence now in the court's hands makes it impossible to ignore. This story is developing by the hour, and as soon as those Supreme Court rulings or the Teterboro Airport filings are updated, I will have the analysis right here. Keep your notifications on, because the next update could change everything. The clock is ticking toward that Thursday hearing, and in this case, silence from the prosecutors usually means a storm is coming. We'll know soon enough if this $1.2 billion seizure is just the beginning or the final blow.